Well, I would too, unless they were an eyewitness. If there's an eyewitness, I think that's different, that they can say, I saw it, or I think I saw it, I was there. If it's just someone who's going to come in and say, I don't think he did it just because there was other people that might have done it, or just a generality of, I don't think he did it, or I think he did it, then I'm not going to allow that. So I'll grant it, again, if there is some testimony that comes out that you believe
on opinion testimony
would make that become...
Just guess guilt or innocence. This is all about facts. Watch closely, because the rules here set the stage for what evidence will actually say.
If there is some testimony that comes out that you believe would make that become... Okay, let's go on the record. State's attorney's present, defendant and defense counsel are present. So on the state's motion in limine that has been filed, not the other additions from yesterday, Mr. Wilkerson, do you have any objections to any of those? It looks like there's 18 requests.
Just a few, Your Honor. So, number 6 prohibits any reference to pretrial incarceration of the defendant. I don't anticipate questioning about how long he served or anything of that nature, but I do intend to question Detective Carmouche about testimony that he previously presented at a bond hearing that I believe is relevant to the testimony that he'll present in this hearing.
I think with that limited I guess, is it when you anticipate questioning him, do you have to say that he already testified to it, or can you just ask him the questions again that you propounded at the bond hearing? Why do you have to say it happened at a bond hearing? Unless he answers differently.
That's what it'll come down to, Judge.
Well, if he answers them differently than any previous test.
This is a great peek behind the courtroom curtain. The judge is explaining how prior testimony can be revisited for impeachment. Basically, if a witness changes their story, lawyers can challenge them. Legal nerd moment. Impeachment isn't about catching lice, it's about testing consistency.
Testimony, then at that point, for impeachment purposes, I would allow it for that limited purpose with regard to the bond hearing and what was testified at the bond hearing. But I think the questions need to first just be asked again, and then obviously if they're different, we'll handle it at that time. So I am going to grant it. If you think at the point that you ask him the questions, the same questions, that if he answers differently, then approach the court, the bench, and then I'm obviously likely to let you get into that. Okay?
And then object to number 8. While the belief of a witness is the purview of the jury, I'm not aware of any prohibition against a witness offering his or her opinion as to the guilt or innocence of the defendant in a case.
Well, obviously, that would go both ways. And so if I were to allow a witness to say, I think he did it, then I think that goes as well to a detective or law enforcement to say the same.
If I may, Judge, I think the distinction with law enforcement is they can base their opinion on their training and experience. For instance, the question I typically ask is, after you've, based on your investigation and the things that you've conducted or did in your investigation, and based on your training and experience as law enforcement, did you form an opinion as to whether or not an offense or offense has been committed?
Right.
The distinction is they're basing their determination or opinion on their training and experience. A lay witness, I'd have a problem with them making that opinion.
Well, I would too, unless they were an eyewitness. If there's an eyewitness, I think that's different, that they can say, I saw it, or I think I saw it, I was there. If it's just someone who's going to come in and say, I don't think he did it just because there was other people that might have done it, or just a generality of, I don't think he did it, or I think he did it, then I'm not going to allow that. So I'll grant it, again, if there is some testimony that comes out that you believe would make that become an opinion that I would allow in, then just approach the bench first before you ask any questions about it. All right?
Also object to number 9.
I mean, that to me is a punishment issue. I would say that nothing needs to be discussed about anything with prison or jail life or incidents that take place during confinement. That would become a punishment issue if we get there. So for the case in chief, I'm going to grant that. I don't think it's appropriate to ask anyone about that during this phase of the trial. If we get to the punishment phase and you believe it's appropriate at that time, we'll discuss that at this point. So I'll grant that as well.
So the consequences of a conviction in the guilt or innocence phase, you don't want to discuss?
Well, that's not talking about consequences. I mean, consequences of a conviction, we've already discussed in voir dire, which is the general punishment range. And so we're not here to talk about the consequences of it. In the guilt innocence, the charge is specifically going to tell them their only job at this point is for guilt or innocence. And so, yeah, I do believe that at this point, the consequences of their determination is absolutely not appropriate to discuss at this time.
Just say that the parallel, I think, is, for instance, asking a probation officer if registering as a sex offender is a consequence of conviction.
That's a punishment issue, not a guilt innocence issue. So I'm going to grant 9.
So, number 15, want that limited to just the guilt innocence phase. There's no allegation that the defendant is unfit to stand trial or that he committed this incident and was temporarily insane at the time. Obviously, in punishment phase, any testimony regarding any type of mental illness or any other mitigating evidence I would want to bring in.
Sure. I think let me say this. This motion in limine is going to be, and the things that I grant or don't grant are for the guilt innocence phase only. If we get to punishment and there is some additional things we need to discuss, we'll take them up at that point. So that will be granted.
Oh, and then I just wanted to clarify on number 18, obviously evidence outside of what's brought in testimony is not proper for the jury's consideration, but I would just clarify that if there is some other reason that it might be admissible, a prior inconsistent statement reflected in some article. I'm not aware of any. I don't anticipate this, Judge, but...
All right, so 18 will be granted. If something comes up and you believe it is relevant and admissible at that time, just approach the bench and we'll take care of it. All right, so that takes care of the state's motion in limine. I have granted it, all of them, obviously with same caveat as always. If there's anything that you believe, either side believes would become admissible and relevant, just let me know. Approach the bench outside the presence of the hearing of the jury. Anything else pre-trial?
Not for the state, Judge. Well, there is a thing. My first is Lieutenant John Courts, Your Honor, with BPD. He recently had oral surgery. Yeah.
Arsenault just let me know as well.
I mean, he can, apparently. So I'm going to ask, with the court's permission, I'm going to lead him. Just ask the questions to yes or no.
Yeah, do the best you can. Obviously, he can get right up and speak. We can change. Have we changed out this filter on the microphone lately? The thing over it. Let's make sure that's a new one and have another new one ready for after Detective Courts so that he can get right up and speak into it so that we can hear him. His wife. Oh, that was something different. And then if there's if it becomes such an issue that we cannot hear him, perhaps there's a way that we could have him write out an answer and it be read and do it that way if it comes down to that.
And I won't, because of that, I won't object to leading specifically with singular factual issues, one fact at a time, without opinion. I would, of course, object to
Sure.
any opinion testimony being evidenced in a leading manner.
I agree. All right, anything else then before we bring the jury in? Mr. Wilkerson, anything?
No, Your Honor.
Okay, how long would either of you request for opening?
10 minutes, Judge.
Okay.
I don't need 10 minutes, but
Okay. All right, then once that's done, we can get the jury in.
my client's asking to use the restroom. The jury's about to be brought in.
Done that already. You want to stop them real quick?
Sorry, Judge.
There's no other sheet under there. So, there's that. So,
Okay, you can bring the jury in. Good afternoon. Let the record reflect the jury is seated, state's attorneys present, defendant and defense counsel are present, and this is again cause number 24 DCCR 2419. And ladies and gentlemen, at this time, if you can remain seated and please just raise your right hands and take the oath of the jury. Do you and each of you solemnly swear or affirm that in the case of the state of Texas against the defendant, you will a true verdict render according to the law and the evidence, so help you God? Thank you. And is the state ready to proceed?
State's ready, Judge.
Defense ready?
Defense is ready.
Do either of you, you can have a seat first. Do either of you wish to invoke the rule?
Yes, Your Honor.
So if you'll please get any witnesses that are here, if they're all out there, bring them in, and then obviously both of you know if any witnesses are not here, if you anticipate any coming, make sure they understand that they're not allowed to be in the courtroom during anybody else's testimony, and please specifically instruct them not to watch any of the proceedings on YouTube.
Yes.
Y'all can come on up. Good afternoon, everyone. If y'all all please raise your right hands. Do you and each of you solemnly swear or affirm that in this case, good grief, I just gave them an oath, and now I'm about to give you the oath of the jury. Do you swear that the testimony you're going to give in this case will be the truth, the whole truth, and nothing but the truth? Thank you. And is that more? I'm sorry. Do we have more coming? Go ahead. Come on up. Y'all can just kind of let them come over. There you go. Perfect. All right, so are both of you or all three?
Thank you. The gentleman, Mr. Barnes in the wheelchair, and Mr. Kale here, Judge.
Okay, if you two would please raise your right hands. Do you solemnly swear or affirm that the test...
Two.
Okay, you can put your hand down, sir. Do you swear or affirm that the test... You raise your hand. There we go. We're going to get it. Do you swear or affirm that the testimony you give in this trial will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. So you're all being placed under the rule, and most of you know what that means, but for those of you who don't, it means that you're not allowed to be here in the courtroom during anyone else's testimony. You're specifically instructed not to talk about your testimony or anyone else's with anyone in the trial other than the lawyers or the investigators. Also, you're instructed not to watch any of the proceedings on YouTube. All right? Thank you all so much. You can step outside. Y'all can go ahead and go back out. All right. At this time, Mr. Coleman, you may present the indictment. Mr. Johnson, if you'll please stand.
In the name and by the authority of the state of Texas, the grand jurors for the county of Jefferson, state aforesaid, duly organized as such at the July term AD 2024 of the 252nd District Court of Jefferson County and said county and state upon oath in said court present that Romeo Randolph Johnson, hereafter styled the defendant, on or about the 14th day of September 2024, and interior to the presentment of this indictment in the county of Jefferson and state of Texas, did then and there intentionally and knowingly cause the death of an individual, namely Ronald Barnes, by shooting Ronald Barnes with a firearm against the peace and dignity of the state.
And how does the defendant plead?
Guilty.
All right, thank you. You can have a seat. Mr. Coleman, do you wish to make an opening statement?
Briefly, Your Honor, thank you. May it please the court.
All right, let the record reflect the jury is outside the presence of the courtroom. I guess my question, Mr. Wilkerson, is yesterday we went into a whole discussion pre-trial about getting into criminal history of the victim, criminal history of the brother. I made a ruling about the criminal history of the victim and that if you felt like at some point that was admissible and relevant, you would approach the bench. We're 2 minutes into your cross-examination and you violated that motion in limine.
Judge, I asked him specifically not to talk about why or what he specifically responded to.
For the implication, Judge.
I guess, where do you get, and I'm not saying it's not necessarily relevant, I'm saying you can't skirt the motion in limine and the order by asking a different question or a more general question. It's, if you're asking that he's been to the house, and then where do you go from that if he says yes? What's the next question?
Then I asked to approach and discuss the fact that the ankle monitors on both his brother and the victim.
But you know that's where you're going, so you approach.
Here's where the narrative shifts from legal procedure to real-life stakes. We get a timeline of the murder and the digital evidence tracking the suspect. Ring Camera's license plate readers, you piece this, is a modern detective story. For the jury, it's not just a law. It's connecting dots with tech.
Before you ask the question about going to the house, you know he's going to say he's been to the house.
Honestly, I don't know if he was involved in that, Your Honor. I really don't. That's why I'm asking the question.
I've talked about we could take some time. You could take a witness on voir dire so that you would know what they were going to say before we went into that. So ask what questions you would, I want to know what the questions and answers would be and where you're headed on this, please, sir.
Had you previously responded to that location?
I don't know 100% if I have or not. I mean, I've been in the North End most of my whole career for, well, I'd say probably 19 of my 23 years I've been in the North End. Mm-hmm. There's a good possibility, but I don't know. You mentioned in the recording that it was one of the twins. How are you familiar with them? Somebody had told me when I walked up. Okay. That was wrong with Donald Barnes. Was that you or another officer on the camera footage that talked about Ronald or Donald, not sure which one? It was me. It was you? How were you familiar with the name of the other individual who lived there by that point? I believe when I walked up, that's someone had told me that I didn't recognize the address when pulling up. And I didn't know which one it was. I knew there was a brother outside on the street and there was a brother that was deceased, but I didn't know which one was which. Who did you contact that evening? You talked about you contacted the lieutenant on call, I believe. Who did you contact that Lieutenant
evening?
Sliger.
Snyder?
Sliger.
Sliger. Can you spell
Sliger, S-L-I-G-E-R.
S-L-I-G?
G-E-R.
Okay. And
You may hear I refer to him, I'm calling Mitch, that's his first name. I told the other sergeant I'm calling Mitch.
okay.
I have nothing else, Judge.
Okay, and I don't have any issues with you asking those questions. Mr. Coleman, would you have any objection to any of that? It doesn't appear that there's any specific information that,
I have a little heartburn about asking him if he's been to that address before.
I don't have a problem with that. I'm going to allow that and overrule that objection. So anything else that you anticipate possibly with this witness?
From this witness? No,
Yeah.
Your Honor, but
Okay.
I think we're gonna, I guess with the investigating detective, we're gonna have to get into,
We specifically talked yesterday about having Detective Carmouche here going through some things without the jury in the courtroom, so we'll take care of that at the appropriate time. Okay, all right, you can bring the, yeah, well, they might not be, they're kind of gone. All right, if anybody needs a quick break, we can take a